He had the legal right to have that gun in his car. He had done nothing wrong. He had not broken a single law. He had a valid permit, a registered firearm, and 40 years of responsible gun ownership behind him. And the officer searching his vehicle legally without a warrant over his clear and repeated objection was about to find something that would change the next 3 years of his life. Not because he was a criminal, because no one had told him the rules had changed. The Supreme Court of the United States just issued a ruling that directly affects every person who carries a firearm in a vehicle. 9 justices, 0 dissents, the most unified decision on gun rights in a generation. And if you keep a gun in your car or you know someone who does, you need to understand what this ruling says, what it protects, and exactly where it will fail you if you don't handle your next traffic stop correctly. Before we get into the ruling itself, one thing. This channel covers Supreme Court decisions, new gun laws, and changes to your rights the moment they happen, not weeks later when you read about them in a comment section, not after you've already needed them. If that's the kind of information you want in your corner, subscribe right now and hit the notification bell. 2 seconds, it costs you nothing. And the next ruling that affects your life will be waiting for you the moment it drops. Now, let's talk about what the Supreme Court just said and what it actually means on the side of a road. To understand why this ruling matters and why it matters to you specifically today before your next drive, you need to understand the problem it was built to fix. The United States Constitution gives every American 2 protections that should never be in conflict with each other. The Second Amendment gives you the right to keep and bear arms. That right is foundational. Millions of Americans exercise it every single day, legally, responsibly, and without incident. It is one of the oldest and most clearly stated rights in our founding documents. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government agent can go through your vehicle, your home, or your personal belongings without either a warrant or a specific legally defined justification called probable cause. That protection is equally foundational. 2 constitutional rights, both clear, both settled, and for years quietly on roads across every state in this country. Those 2 rights had been crashing into each other in a way that most gun owners never knew about until it was too late. Here is the collision. When an officer pulls you over and learns you have a firearm in your vehicle, what does that information legally authorize him to do next? Can he search your car based on the gun alone? Even if that gun is completely legal, even if you have done absolutely nothing wrong, even if there is 0 other evidence of criminal activity, courts in multiple states were beginning to say, yes, the reasoning being built in lower courts went like this. Firearms are inherently dangerous. Therefore, a firearm in a vehicle creates an inherently unsafe situation. Therefore, the officer has an automatic right to search regardless of whether any crime has been committed. Follow that to its conclusion, and you reach something that should alarm every gun owner in America. If the mere presence of a legal firearm gave law enforcement automatic search authority, then exercising your Second Amendment right would simultaneously strip you of your Fourth Amendment right. You could not have both. You would be forced to choose. That is not what the Constitution says. That is not what any honest reading of the Constitution has ever meant. But it was happening in real cases to real people, and it was spreading until a case reached the court that could not be ignored. Cases like this one don't start in marble courtrooms. They start exactly where yours would. On the side of a road, a driver is pulled over for a minor traffic violation. Nothing serious, the kind of stop that should end with a warning or a small fine and take less than 10 minutes total. The officer approaches the window. The driver is calm. His hands are visible. He is cooperative from the first moment. He discloses clearly and without hesitation that there is a legally owned firearm in the vehicle. No erratic behavior, no suspicious movements, no indication of criminal activity of any kind. By any objective measure, clear this is a model interaction between a responsible gun owner and a law enforcement officer. The officer looks at the situation and makes a decision. He decides the gun is enough. That the presence of a firearm, regardless of its legality, regardless of the driver's demeanor, regardless of the complete absence of any other red flag, justifies a full search of the vehicle. The driver objects calmly, clearly. He states he does not consent to a search. The search happens anyway. The case moves through the court system. And here is the part of this story that should genuinely disturb you. The lower court sided with the officer. They ruled that under these circumstances, the presence of a firearm alone was sufficient legal justification for the search. They essentially concluded that being a gun owner made a person suspicious enough to forfeit their privacy. One constitutional right used as the justification to override another. Then it reached the Supreme Court of the United States. And what happened in that chamber is something that almost never occurs, particularly on anything touching firearms and law enforcement authority. 9 justices, every ideological corner of that bench, from the most conservative to the most progressive. They looked at this situation together. They deliberated and they arrived at the exact same conclusion, 9-0. No dissents, no partial concurrences on narrow grounds, no splits, a unanimous across-the-board ruling from the highest court in the land. When 9 Supreme Court justices agree unanimously on anything involving guns and police authority, you pay close attention because that level of agreement does not happen by accident. It means the constitutional line being drawn is not subtle, not ambiguous, and not open to reinterpretation by lower courts. It is clear enough that 9 very different legal minds all arrived in exactly the same place. Here is the core holding of the ruling. Every word matters here. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Let me break that down into plain language. Legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat either of those things as if they are. The court delivered a direct, unambiguous message to every law enforcement agency in the United States. You cannot use a citizen's exercise of one constitutional right as the justification to strip them of another. The Second Amendment and the Fourth Amendment exist together. They stand together. A law-abiding gun owner is entitled to both at the same time without condition, without having to choose. The court's language on this point was precise and unmistakable. Armed does not mean criminal. 9-0. Now, here is where most people watching this video make the mistake that turns a good ruling into a dangerous false sense of security. You are thinking this ruling is a force field. That the next time an officer approaches your window, you have a 9-0 Supreme Court decision protecting you and the conversation ends there. It does not end there. Treat this ruling as a complete and absolute shield, and it will fail you possibly at the worst possible moment. The court ruled that illegal firearm does not by itself create probable cause. Those 2 words by itself are doing the heaviest lifting in this entire ruling. The moment other factors enter your traffic stop, the legal calculus changes and it changes fast. There are 3 specific trapdoors built into this ruling. Know them cold before you ever need them. The ruling protects people who legally possess a firearm. It does not protect prohibited persons. If you are legally barred from possessing a firearm due to a prior felony conviction, a domestic violence restraining order, or any other disqualifying factor, this ruling provides you 0 protection. The gun is not a neutral detail. It is evidence of a crime. Furthermore, if the officer has any reasonable, articulable suspicion that the firearm itself is not legally possessed, the analysis changes immediately. An officer who suspects you should not have that gun does not need additional probable cause to investigate. The suspicion of unlawful possession is the probable cause. This shield works only when your legal status is completely clean. If there is any question about your right to possess that firearm, the ruling does not apply. Here's where many responsible, law-abiding gun owners get caught, and it is entirely avoidable. Many states have specific laws governing exactly how a firearm must be stored inside a vehicle. Some require the firearm to be unloaded. Some require it to be in a locked container. Some restrict which area of the vehicle it can be located in. If an officer approaches your window and observes a firearm stored in direct violation of your state's storage statute, the 920 ruling will not help you. The officer is not searching based on the presence of a gun. He is searching based on specific, observable, articulable facts indicating a criminal violation of a storage law. The gun is still legal. The manner of storing it is not. And that distinction, while it sounds technical, is the difference between this ruling protecting you and this ruling having no relevance to your situation at all. Know your state's firearm storage requirements before you put the car in drive. This is not optional. This is preparation. The ruling stops officers from using a legal firearm as the only justification for a search. It does not stop them from using it as one factor among several. Picture this. You are pulled over. You have a legal firearm, but your passenger is visibly nervous in giving contradictory answers. There is an odor of a controlled substance in the vehicle, and you are providing inconsistent information about your destination and your recent activity. The officer is not going to argue he searched because of the gun. He is going to argue he searched because the gun, combined with the smell, the behavior, and the inconsistent statements, collectively created probable cause. He may be legally right. The Supreme Court did not abolish the automobile exception to the Fourth Amendment. It did not restrict officers from investigating genuine evidence of criminal activity. What it stopped specifically and precisely is the use of a lawful firearm as the sole and only justification for a search. Every other factor at that stop still matters. Every other factor can still be used. That line is where this ruling does its real work, and also where it has its real. Now we get to the single most dangerous moment of any traffic stop involving a firearm. Not when the officer approaches, not when he sees the gun, not when he asks for your license. The most dangerous moment is when the officer realizes he does not have enough to legally justify a search, and he tries to get you to give him permission anyway. He will say something that sounds completely professional and reasonable. Something exactly like this. Since you've got a firearm in the vehicle for your safety and mine, do you mind if I just take a quick look through the car? He is polite. He sounds like he is doing his job. Every instinct you have as a cooperative, law-abiding person tells you to say yes. To prove you have nothing to hide, do not say yes. The moment you say yes, the moment you say sure, go ahead. I don't mind. The 920 Supreme Court ruling becomes completely irrelevant to your situation. You have handed the officer a blank check. Glove box, trunk, center console, your personal bags, all of it. Consent overrides the court. This is not a legal technicality. It is the foundational principle of Fourth Amendment law. If you voluntarily consent to a search, you have waived your protection, and that waiver cannot be undone in a courtroom. Not even with this ruling behind you. Understand this? Absolutely. This ruling is a shield. Consent hands that shield to the officer. Here is your complete protocol step by step. From the moment those lights appear in your mirror to the moment the stop ends. Step 1. Pull over immediately and correctly. Signal. Slow down. Move to the right shoulder without hesitation. Do not give the officer any reason to question your intent. A delayed or uncertain pullover creates tension before the interaction even begins. Step 2. Control every variable in the environment. Turn off the engine. Roll down your driver's side window fully. If you have tinted rear windows, roll those down too. This removes the visual uncertainty that makes officers tense before they reach your door. If it is nighttime, turn on your interior dome light. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for your registration. Do not reach for your wallet. Do not move until the officer is at your window. Step 3. Speak before you reach for anything. When the officer asks for your license and registration, do not immediately reach. If your firearm is anywhere near your document storage area, an unannounced movement toward that location is exactly how calm interactions become dangerous ones. Speak first. That one sentence does 3 things simultaneously. It demonstrates complete cooperation. It eliminates surprise. And by asking how they would like you to proceed, you place the decision in their hands, communicating clearly that you are a responsible gun owner following a protocol, not a threat. Most officers respond to this approach immediately and positively. Step 4, know your state's duty to inform. Some states legally require you to inform an officer immediately that you are carrying. Others have no such requirement. This varies and it matters. Know your state's law before you need it. If your state mandates disclosure, comply immediately and without elaboration. If it does not require disclosure and the firearm is not visible, you have no legal obligation to volunteer that information unless you are directly asked. But if you are asked directly, a single lie to an officer can transform a routine traffic stop into a criminal situation faster than almost anything else that can happen at that window. Step 5, refuse consent calmly, briefly, firmly. When the officer asks if he can look inside your vehicle, and he may ask, this is the moment your rights either protect you or fail you. So, do not argue, do not lecture, do not reference this ruling. Simply say, if he responds with, if you have nothing to hide, why not just let me look? Recognize that for exactly what it is. Psychological pressure designed to make refusal feel like guilt. Respond calmly, then stop talking. You are not on the shoulder of a highway to win an argument. You are there to protect your legal position so you can win later in a courtroom with an attorney beside you. Step 6, use silence deliberately. Silence is a legal tool and one of the most powerful available to you. It is a protected exercise of your Fifth Amendment rights. Do not fill quiet moments with nervous explanation. Do not answer questions like, where are you headed? Or, is there anything else in the car I should know about? Unless you choose to. You can say most people talk their way into a search. Every sentence you volunteer hands the officer another building block toward probable cause. Silence removes every one of those blocks from the table entirely. Step 7. If the search happens anyway, do not physically resist. If the officer proceeds to search your vehicle after you have clearly and calmly refused consent, do not interfere physically under any circumstances. State clearly and loudly enough for his body camera to capture. Then stop. Do not repeat it. Do not escalate. Let the officer's actions become the entire legal story. Every step taken after an unlawful escalation is now subject to legal challenge. Every piece of evidence discovered in a search that should not have occurred becomes potentially suppressible in court. Your composure in that moment is not weakness. It is the foundation of your entire legal case. Step 8, document everything before you drive 5 miles. The moment the stop ends, pull over somewhere safe and write down everything while it is still accurate. The exact time and location, the officer's name and badge number, the precise words exchanged during the stop, whether you consented or refused, what justification, if any, was offered for the search, what was or was not found. Human memory degrades rapidly and selectively. Specific contemporaneous documentation is what attorneys use to build winning cases. Vague general recollections are what cases are lost.